Welcome to the Investor Coaching Show, a podcast to help you get an insider's view of the financial world and escape common investment traps. We look at the financial news of the day and help you make sense of it so you can relax about money. And here's your host, Paul Winkler.
All right, back here on the Investor Coaching Show, Paul Winkler. Talking money and investing. And estate planning today. In this particular hour, Parker Brown here from Fidelis Law, down in the Cool Springs area. Throw out their number, 615-370, there we go. 370-3010. Yeah, there we go. It's funny because I had the number in my head all the time.
Yeah, right.
I should have been able to get that right. 370-3010. Okay. So Parker, we were talking about wills. A lot of people, they hear the idea of probate and they go, oh, it's terrible. It's awful. Yeah, if you live in California, for sure. If you live in New York, yeah, for sure. No question. There's some states that it's absolutely almost incumbent upon you to do a living trust because of the complexity and how awful the estate planning process can be after somebody passes away. And then a lot of people don't realize that, you have assets that pass by a law. You've got beneficiary designations, TOD, POD designations and those types of things, or joint ownership and those types of things. And when we're dealing with probate, we say, well, you look at it and it used to be that maybe you had percentages of the estate that would go out in that, and not so much the case anymore, as you said. What are some of the things that people can do to reduce costs that are outside and maybe not do a trust, but things that they can do with a regular will to reduce some of their expenses for probate?
Right. There's absolutely things you can do. If you're at home now looking at your will and you want to say, hey, I'm doing a will, I'm not doing a trust for any of the reasons we talked about, always look at your will and make sure it waives three things, is what I tell people. Make sure it waives bond. So during a normal probate, the executor has to actually go obtain a bond for the asset value of the estate. Mm-hmm. In case the executor runs away with the assets, the estate's bonded. Mm-hmm. Inventory. So the inventory and executor also within 60 days of probate being open.
No, waives bond so that you lose protection.
You do.
If you waive it.
You do. So you need to trust to your appointing.
I want to make sure you said that. Okay.
Exactly. You don't waive it for anybody. But and inventory, so you have to file an inventory within 60 days. So that's not always the most costly thing, depending on how detailed your inventory is.
Inventory, explain that a little bit.
So in inventory, you would file what is part of the estate. And so again, that can be what's part of the probate estate. And so that can cause confusion too, because really what you're filing with the court is just what's going through the probate process. So what we talked about earlier, if there was a bank account that was co-owned with a child, it would not be on that inventory. Mm-hmm. If there was a IRA with a payable on death beneficiary, it's not on that inventory.
So you're talking about what the value of the car is, the value
personal
of maybe
property,
collectibles, might be, the china cabinet and
everything. Yeah. So it
or do you just lump everything under furniture and just
every court's different. Most of them it's just kind of household items or personal property. And so, like I said, some estates it's easy. It's, hey, my inventory is one bank account, one thing. But other states, your attorney can spend a lot of time working on that inventory.
Well, what's Tennessee like?
Tennessee just depends on the county, but they're all you list out. They're mostly broken down into like real estate. So you would list real property part of the estate. Usually cash, stocks. They break down kind of 15 or 16 things. Recreational vehicles, personal items, all sorts of different stuff that can be included on there.
So is this like a list of things that you said it depends on county to some extent?
As to the format they want. Is
there anything that anybody can do, to make life a little bit easier for their kids?
What I always tell people as far as in the wills, waive that inventory just so you're not necessarily filing that. And the third thing to waive is, so Tennessee requires interim accountings for an estate, which would be 15 months from essentially when the estate's open. You would have to file an accounting, which that is where these things we're talking about waiving the inventory and accounting. The reason you're saving your estate a lot of money and time is the attorney is going to be the one probably doing that. So the more you waive, the less you're spending on the attorney. So our probates where we don't have to do inventory and accountings are the cheaper, easier probates because your executors not having to report as much back to the court.
So this is something you do in the setting up of the will process.
You
waive these things.
Your will, and most wills do, but always check your will and see if it waives bond, inventory, and account.
Okay.
So that's a good way to help make the probate easier if you have it.
Mm-hmm.
Think other things people can do in their estate planning that I've seen help a lot in probate, to answer your other question, is I tell people, tell your kids, write down, where do you bank? Where do you have assets? Who's your financial planner? I tell people, don't necessarily put passwords and things like that on there, but just tell kids where your stuff is. And because I mean, a lot of people, they don't know where mom or dad banks. They don't know if mom and dad, they don't know they opened a stock account here. Like, the more you know, the less digging they have to do as part of the probate process, for sure.
We actually have, and a lot of our clients may not even know this, so I'm kind of telling myself that I haven't communicated this that well, but we actually have a love letter, which is a little booklet that does that kind of stuff. So if you're a client of our firm, Paul Winkler, just let us know that you want that thing, and we can get that to you.
That's huge help. Yeah.
Yeah. So, okay. So, as far as that goes, those are some of the things that you can do to make things a little bit easier. Tell me what else that I need to know about probate that I'm not necessarily thinking about, things that I might be dealing with. You know, you were talking about the executor, executrix, if it's a female, you know, the functions, the things that they have to do. I was dealing with an estate earlier this particular week. They haven't passed away yet, but we were talking about the choice of the executor being an out-of-state person versus somebody that's in-state. Talk a little bit about how much work there is to being the executor or executrix. And should you try to find, as best you can, somebody that lives in the same area that you do? And talk about, is that a big deal?
There's a lot. It's a big role. We tell people usually when they come in for that first meeting, like, hey, this is a fairly big role, big responsibility. How big does depend on if you waive some of those things. So they're always thrilled to hear that bond, inventory, and accounting got waived. They don't have to go get a bond. As far as, I mean, we do deal with a lot of out-of-state fiduciaries. You do have to register them with the Secretary of State here, so that's kind of an extra step. For out-of-state, it also kind of depends on the county. Like we talked about earlier, we have plenty of out-of-states that they never have to come here because you don't have to appear here. And so, depending on the county, I would ask your attorney drafting your estate planning, hey, would my executor have to appear? End of the day, though, the main thing would be trust. Just make it someone you trust. Make it someone who's responsible. If you do have the 3 kids that haven't talked to each other in 10 years, probably don't make it one of them. Make it maybe a trusted friend or someone in the family, someone that you know is going to be impartial when kind of making those decisions. So the executor is a very big role in that.
Yeah, I can just imagine some of the things that you have to deal with just thinking about, you know, because like for me, my sisters and I, we get along famously,
right,
you know, incredibly well. But, you know, you do have those contentions with people. And when it comes to money, people's personalities change as well.
And a lot of times we see they're a close family. And then that one person that was kind of the glue holding everybody together, when they pass away is when everything kind of blows up. And that goes back to what I talked about. Our most expensive, most complicated probates are the ones where the family just can't stand each other.
How about guardianships, those types of things?
So guardianships are very important if you got children under 18. We tell people all the time, we can help you limit when your kids get their money. So you can make it 25, 30 when they get their money. You can't help it physical guardian when they're 18. So with guardians, we always kind of tell people, same thing. There's some people have a different thing on who they want to maybe manage the finances for their kids versus who they would just really trust to raise their kids. And so we tell people those don't have to be the same. You can make people who you really just love their parenting, or a sibling or a parent. You can appoint them as your guardian. You can appoint somebody else as the trustee of kind of their funds or their financial aspect of it.
Okay,
sure.
You ready for this one?
I'm ready.
Because sometimes I see people do this and I just go, oh, I get that look on my face where we're transferring our house to our child because of Medicaid 10-care planning. Talk about that. I'll just let you run.
Yeah. So a few things on that. our firm doesn't do a ton of, I would say, special needs or planning or anything like that. But
I'm not even talking special needs. I'm just trying to talk about, somebody wants to get on Medicaid for long-term care.
Right. So one thing we always tell people,
it.
Tennessee has a 5-year look-back period. So if you do that and you start getting any of that money within the next 5 years, they can negate essentially whatever you do in that transaction. And I mean, a lot of people also say like, well, if I don't want to do a trust, like why don't I just put my son on my house now with a right of survivorship? And I mean, you can, but the problem when you do that though is then you're messing up.
Your son gets sued, and then all of a sudden you've lost your house.
Exactly. And it's better basis wise for them to inherit that asset than for you to put it on now.
So he's talking about tax basis. So when you get a step up in basis where you buy a house and you got $100,000 in it, and it's worth $500,000. When you pass away, you got a $400,000 gain. But if it's gone and transferred at some point earlier, you can lose out on a lot of that gain step up, and then end up with a situation where you got a tax problem on your hands. Then there's that little situation I have seen, where all of a sudden a child inherits something promising they're going to take care of their parents. And then all of a sudden what ends up happening is the child, maybe they get married to somebody that isn't so great. And then all of a sudden, I have seen the parents pushed out of a house.
Right.
I've seen that happen. It's my house now, and you're gone.
And that's what we warn people about all the time. If they're like, hey, no, for kind of reasons you said earlier, we want to put our son on our house. We trust them. We know we still own it, essentially, because we live there. Well, you don't. Your son owns it at that point. And if he's a great son, it's probably not going to be an issue. If he gets the wrong person in his life or in his year, like you said, or lawsuit, like you said, then big issue. So.
And keep in mind also, from a perspective of financial planning perspective, you're trying to qualify for welfare. And you are not in control anymore of where you might live, what area you might live in, the quality of the housing, because you're not the payer anymore. And you might actually trigger something that you wish you hadn't triggered when it comes down to it. So be very, very conscious of these types of things, because I've seen people do it. They don't get any counsel. They don't have anybody helping them out making these decisions. And it might be an irrevocable decision. You can't do anything about it later on. I've seen it turn into nightmarish type circumstances. Paul Winkler, you're listening to the Investor Coaching Show right here on Super Talk 99.7 WTN.
Hey, just a note to you podcast folks, we just came out with a retirement income guide, and I'm super excited about this. There are all kinds of myths about taking income in retirement. People worry about running out of money. And rightfully so, because a lot of these myths can actually cause that. Now, the myths that you typically hear about, number one, like dividends, living off dividends in retirement, real estate, life insurance as a retirement investment, and annuities, and interest-bearing accounts, and target date funds. There are all kinds of things out there. What I want to do is put something together that walks through why those things are problematic, number one. Number two, the other thing that I wanted to do is walk through the evidence-based research on taking income in retirement. And we got a ton of data going all the way back to 1900. What's the logic behind it? And it's intensely logical. So we put that together, and all you have to do to download that, making it super simple, just go to paulwinkler.com/relax, and you can actually get into that very easily right there. So I would urge you to do that. Check it out, because I think you're going to really like it. paulwinkler.com/relax.
All right, we're back here. Investor Coaching Show, Paul Winkler, along with Parker Brown, talking about estate planning, talking about probate process, what's involved, what people should know, common mistakes. If you missed any of it, you go back and check out the podcast at paulwinkler.com. That's where it will be. Okay, Parker, talk a little bit about the timeline. How long is this going to take?
Right.
This process.
That's usually the first two questions clients ask is how much is this going to cost and how long is it going to take? And we talked a little bit about the cost, but as far as timeline, they greatly vary. So there's not what I'd tell people like a maximum timeline. Some probates go on multiple years. Some probates are much shorter. The key kind of timeline to walk through and with a probate is Tennessee, if you pass away, creditors essentially have 1 year to come after your assets. But what happens is when you open up a probate, if it is for someone who's died, obviously within the last year, once you get appointed, there is a publication to creditors. So that is a publication in the paper, local paper for the county that you're doing the probate in, that goes out to any unknown creditors. And that is usually published twice. And the first time that is published starts what is called a 4-month creditor period. So that is a 4-month period that creditors are supposed to file claims against the estate. The good news about that period is anybody that you know of that's a creditor and you notify them of that, it cuts them from that 1 year to that 4-month period. So you can kind of really clean up an estate quicker instead of waiting that year. So I tell people, though, you're not going to be able to close probate until that 4-month period ends. So I always tell people the easier way to explain the timeline is the minimum is that creditor period. And then there's always, do you have to file a final estate return? There's asset that hasn't sold yet, things like that. So, but the minimum timeline is kind of what I tell people as far as that goes.
Okay, so you had mentioned a couple other things that you said 10-care releases and those types of things. What on earth? Explain.
So Tennessee, the main creditor they care about above all is 10-care. Do you owe 10-care money? And so every estate, if you were over 55, because they only come after people over 55, then you have to file for what's called a 10-care release, which is a simple one-page form where 10-care comes back and either says, yes, they did owe us something and they owe us X, or no, they didn't owe us anything. So that's part of the process.
Yeah, and so what he's talking about there, so let's say you have a situation where you end up in a nursing home and there are expenses that are paid for by, it's kind of, Medicaid is what you hear about in the rest of the country. Where Medicaid is welfare. And then in Tennessee, you have 10-care. Then let's say that you have an asset that was not in that, your house or your car or something like that. And, they want to give you the ability to hang on to your house while you're in a nursing home. So that's part of the deal. But they're going to want to make sure that they get their money back. So that's what he's referring to there.
Exactly. And it is most commonly real property, like you said, because you can't have much else. So it usually is the house.
Yeah. And so that is something to keep in mind. Now, people that try to pull this thing off on their own.
That is another good reason some of these last a long time. I would say probate it's a complicated process just because there are so many timelines, so many filings, and if you don't file them the right way or tell the court the right thing at the right time, that's when you're getting into bigger issues, not only for the estate and the people getting their assets, but potentially personally if you as the executor. So if you're an executor, hire an attorney, get them to walk you through the process. Doesn't have to be us, just anybody, any attorney you trust. But I do not ever, I would say 99% of the time we have people tell us that they're going to try it pro se. They come back to us a month or so later and say, help me fix what all has happened. And then that's more expensive than if you would have just paid an attorney to begin with. So.
Yeah, and something just from the financial planner perspective, a lot of times the planner is going to be working with the estate planning attorney. I have a lot of joint meetings with estate planning attorneys, where we're going through some of these things. But one of the things that I often will tell people is really be conscious of making sure that you're dealing with an attorney that has experience in this particular area. This comes from personal experience or people I've known where they've hired an attorney and the attorney says, oh yeah, I can draft a will, or I can draft a trust, I can do this type of stuff. And then you come to find out once the person has passed away that no, they didn't know anything about this area. They pulled out a boilerplate type of a form. And speaking of boilerplate, that's another thing real quick. What do you think? Some of the nightmares that people run into when they have these little, documents they pick up at an office store.
Right. And like I said, we've had probates that they've worked, but we've also had a ton where they're too cookie cutter for what you didn't want or need to be cookie cutter. Yeah. And so that causes all kinds of issues.
You don't know what you don't know.
Exactly.
Paul Winkler, along with Parker Brown, Fidelis Law. Again, their phone number 615-370-3010. Worked with these guys for a long, long time, so I really have enjoyed working with you and Robert Patinas over there.
Hey, this is Paul Winkler. Hope you enjoyed today's edition of the Investor Coaching Show. If you want to learn more about what we do, go to our website, paulwinkler.com. Until next time, I'm Paul Winkler, reminding you that I believe that more educated investors are more confident investors, and confident investors are more successful investors. Have a great one. Advisory services offered through Paul Winkler Inc., an SEC-registered investment advisor. The opinions voiced and information provided in this material are for general informational purposes only and not intended to provide specific advice or recommendations for any individual. To determine what investments are appropriate for you, please consult with a financial advisor. Paul Winkler Inc. does not provide tax or legal advice. Please consult your tax or legal advisor regarding your particular situation.